Hello, everyone, and welcome. My name is John Harkins. I am the Events Associate for the French American Chamber of Commerce, New York chapter, and we are happy to welcome you to our webinar today, Preparing to Reopen the Office, Legal and Insurance Considerations for Your Business. Just a very quick word about our organization here before we begin. The French American Chamber of Commerce's mission is to provide the opportunities, experiences, and understanding that empower successful business relationships between and for members. The FACC New York chapter counts a mosaic with 1,000 members, representing sectors from tech to food, finance, and other professional services. These members have complimentary access to digital events featuring top industry experts and leaders, as well as personalized member-to-member introductions, access to the FACC member directory, and of course, we'll be able to connect with other member attendees of this webinar. This webinar itself will last about 45 minutes or so. I encourage everyone, if you have any questions, send them in using the questions section of your GoToWebinar portal, and we will do our best to answer each one towards the end. And of course, this webinar will be recorded and the slides will be available to all attendees, so don't worry about missing a thing. Just very quickly before I turn it over to our speakers, as businesses cautiously look to reopen, there are naturally many new and different challenges which must be considered prior. To ensure you do not put your customers or employees at risk, join us as we discuss mitigating these risks before, during, and after reopening your business. Our speakers today are William Newman of Becker, Glynn, LLP, and Rob Tockarshewsky of USI Insurance to discuss best practices and steps you can take in order to properly reopen your business. Rob, Will, I won't keep us waiting any longer, so would you like to take it over?
Sure thing. Thanks so much, John. Hi, everyone. I'm Will. I'm an attorney. I represent businesses here in the city and all over the country. Rob is with us here too. Rob works in the insurance industry. And one thing that a lot of people have been talking about recently has been businesses reopening as the pandemic has progressed and have people getting the opportunity to restart their businesses. And before doing that, there are a lot of things that businesses need to consider to make sure that when they reopen, they're covered if something bad happens, and that they avoid legal liability or could reduce the likelihood of a costly lawsuit in the event that someone gets injured or any other repercussion that happens as a result of their reopening. Now, before starting this webinar, Rob and I were kind of wondering how come there aren't other people talking about this subject. And when we Googled COVID-19 webinars, we learned that there are really only about 145 million other COVID-19 webinars. Why so few? And I think it's because people don't realize about the complexity of the issues involved in reopening a business in the middle of a global pandemic. But it turns out this is a complicated subject with a lot of things that people need to think through. And in particular, there's no one-size-fits-all answer to any individual business. And over the course of the next 45 minutes, I don't think that we can impart to you every legal issue that you could come across, every insurance issue, or to put you in a position where you would know whether your insurance policy applies or whether the actions you're taking are enough to avoid a lawsuit. But one of the things that Rob and I hope to do over the course of the next 45 minutes is to alert you to the type of things you should be thinking about and the sort of issues you should raise to a lawyer or to an insurance professional before opening your business to the public at large or even to your own employees. Rob, do you want to talk about some of the things that people should think about?
Sure. So let's go to the next slide, John. So first of all, COVID-19 is a unique situation in that it's really put businesses and individuals alike into really uncharted territory. And not only are you in uncharted territory, but you're also in a situation that's very fluid, as different parts of the country are reopening in at different times, and different types of businesses have certain types of restrictions that previously they didn't have. There really is a lot of fluidity to what's going on out there from a business perspective. So most of the folks that we're speaking to right now, obviously your business is probably up and running in one fashion or another. Maybe it's not, in most cases, unless you were considered essential, and even if you were deemed essential, Many times you still have restrictions or certain types of restrictions in place, either locally, regionally, or federally, or you decided upon yourself to keep your employees or your location or your customer base or whatever may be safe. Really, so in thinking about it, there's two guiding questions that you should be aware of, and you should be constantly thinking about, not only before the reopen, but even during and after. And that's, am I doing what I'm supposed to be doing as a business owner? You know, keeping informed is essential, but it's ongoing. So as a business owner, you really have the responsibility to keep informed as to best practices that you should be undertaking, limitations or guidelines that exist that are out there, as well as, you know, concerns that you're hearing from employees or customers or anybody within your supply chain. And the second, you know, question is, if I don't do what I'm supposed to be doing as a business, maybe accidentally or negligently, you know, if I'm not doing it, what are the consequences legally and financially? Because what you're going to find is that regardless of whether it was intentional or accidental, you're going to have some pretty severe financial impacts that will occur that you're going to need you want to mitigate beforehand versus having to do something after the fact. Let's go to the next slide. All right. So first and foremost, employee and customer safety are at forefront. You know, we've been, you know, both Will and I, when we talk to different clients and different types of businesses, you know, it's paramount that you either have a consultant or at least someone within your organization that's designated to implement and take responsibility for safety measures. It's going to be hard for you to, if you're a business owner or a small business, you know, do it yourself alone. You need to have someone that's going to be dedicated full time to be and keep aware of the situation that's out there. You know, the other thing is you're going to need for best practices, and really best practices include, and in no way, you know, is this a comprehensive list, but best practices, talk about if you have a cafeteria, you know, maybe having that closed, no open areas like a cafeteria, temperature checks on a daily basis of employees, mandatory testing and reporting, social distancing and certain types of barriers if in the workplace. And then minimizing the number of people on presence, whether it's, you know, continuing teleworking, which a lot of businesses are doing, or bringing employees back in various or staggered shifts. But at the end of the day, there's a reason why there's 145 million websites for COVID-19 webinars when you do that Google search, because there is a lot of things you should be aware of and best practices that you should be engaging on. So we'll talk a little bit about that, but there's ones that deal specifically on that. But we want to, again, impart upon the audience the considerations that legally and financially and insurance perspective that you want to be aware of. So let's go to the next slide.
One thing I want to talk about in particular with respect to the best practices is the fact that I know that best practices can be costly. Social distancing requires, you know, more space or perhaps fewer employees on premises. And if you have fewer employees kind of spaced out more, productivity could go down, erecting barriers can cost money. But one thing you should know is that the money that you would lose by taking these practices or that you lose because of reduced productivity are probably still less than the cost of a lawsuit. And so I know that a lot of businesses feel that this is a time for belt tightening and not a time to be spending money on these, you know, additional things that look like luxuries, but they're really not luxuries in comparison to the much greater costs of a loss or of an insurance claim or of a litigation, even if ultimately you weren't held to be liable. Let me talk about one area where litigation could possibly come up, and that is in employment issues. So before I talk about employment issues, there's like a chat feature in this webinar. So first of all, feel free to write some chat messages. If you want to tell me that I need a haircut or a shave, feel free to write that. But I want to ask you guys if the companies that you work for or operate have taken grant program money. If that's the case, I want to know about that because there's additional things that you guys should consider. But if not, tell me that too, because it'd be interesting to know to see if the chat function works. But before we get to that, let's talk about layoffs. So a lot of companies have laid off employees because there just hasn't been business coming in, or because it's been a very uncertain time. If you have more layoffs to come, I urge you to take a look at any employment agreements that you have with the employees that you're laying off. It could be that you signed an agreement with an employee years ago that guarantees them some form of employment, or some sort of notice that you have to give them, or additional compensation to which they're entitled. And if you don't pay that, or don't follow the agreement as it's written, even if it was years in the past and didn't contemplate there being a giant pandemic, there could be legal consequences. So look for any agreements that you have with employees. Let's say you have a collective bargaining agreement that doesn't just apply to one employee, but to multiple. That's something that you should look at as well. And even if you don't think that there's an employment agreement, but when you onboard new employees, there's offer letters given to those employees, those could be considered to be enforceable agreements, as are employee handbooks, employee manuals, even like oral communications you've given to employees that would tell them about what they could expect in terms of guaranteed employment, or what would happen if there, if there were to be layoffs. These are things that you should consider and review before laying off any additional employees. Another thing you should do is to make sure that you're consistent with your layoffs. A lot of employees don't like getting fired or laid off, and when they talk to a lawyer about it, one of the first things that an employer's lawyer will tell them is to consider if they have a discrimination claim. If you are firing multiple people, or even one person, ask yourself, am I disproportionately laying off people who are women, people of color, disabled people, older people, LGBT people, anyone that's in a protected class? Because if you are, if you don't get a release from the people when you lay them off, usually coupled with a severance, there's a chance that they'll talk to a lawyer that may assert a discrimination claim. Even if you think you're not being discriminatory, if you look at it from the perspective of an employee's lawyer, the employee's lawyer may assert the claim, and it would cost a lot of money to fight the claim, even if you ultimately prevail. When it comes to existing employees that aren't the subject of a layoff, you should write down what your expectations are with those employees and consult with them to make sure they're comfortable. Why is that? Because later on, if they claim that you put them in a situation that they thought was unsafe, you want to be able to go back and say, actually, they approved that, they assumed this risk, this was something that everyone was comfortable with. And if it turns out they're not comfortable with the risk, that's something you should know about and work out with the employee ahead of time, as opposed to putting them in a position where they feel uncomfortable, because odds are their productivity will go down, or they'll find some workaround and not do the work that you're expecting them to do because they feel unsafe. If there's people that need scheduling or safety accommodations, you should make those, not only because it's the right thing to do, but because there could be legal reasons that require you to provide scheduling and safety accommodations. One upside for employers is that, generally speaking, the workers' compensation law, particularly in New York, protects employers from claims by employees that they got injured on the job. So you don't have to worry about them directly suing you, as long as you have workers' compensation insurance. But of course, the flip side is that the more claims that employees make that they got sick on the job that workers' compensation pays, the higher likely your premiums will be for your workers' compensation insurance. Lastly, I want to talk about employee privacy. Oftentimes if someone at your workplace gets sick, you may want to tell other employees, hey, Jane Smith got sick from COVID, so you should be careful. The workplace may have some sort of COVID-19 contamination. Although the right thing to do is to disclose if there's a risk in the workplace, the wrong thing to do is to immediately disclose the name of the employee without their consent. So before disclosing a name, make sure the employee is okay with it and comfortable, because otherwise there may be exposure because of lack of privacy or defamation, or any sort of other lawsuit that you probably don't want to worry about, that you could head off at the pass early by having the conversation. So I see in the chat that either everyone's chat function is broken, or no one here is using a grant program, or no one wants to admit to using a grant program.
No,
So
actually, Will, I have gotten just a quick response, and the response is no, that they haven't. So for those who might have not answered and have not, would you be able to point in a a proper direction, or any type of advice from your perspective?
Sure. So one of the biggest grant programs is the Paycheck Protection Program. And there's a bunch of resources online, and folks can email me and I can point you in the direction of a couple that are available online, although they're also scattered in those 145 million Google results. But one of the major things that you should consider if you are a recipient of these grant programs is to make sure that the approved percentage of money that you took in went straight to employees. And if it didn't, then it may make more sense to defund some of the other priorities or things that you spent some of that money on, and make sure that the rest of the money goes on to holding on employees, even if there's not work for them to do. But there are a bunch of other specifics that you should consider, which you can find online, or please get in touch with me and I can point you towards them. But let's take a look at the next slide. So here, there are a bunch of different areas where there may be legal and insurance obligations for you to consider. A lot of people think that the law is kind of written in one big place and your obligations kind of, are listed in one area. But the truth is that your legal obligations come from a variety of different places. So I'm going to have another question for people to put in the chat as I go through this. But one thing I want to ask people is if they own the property, or their business owns the property where they are, or if they have a lease, because different obligations arise if you're under a lease, clearly because you're a lessee, and other ones apply if you own the land that you're on. So please feel free to put in the chat, even though I can't see the chat, whether you are a lessee or a landlord, because different obligations could arise. But in either case,
Sorry, Will, very quick responses. We have two that have said they're under a lease, and so still waiting on the others. But if you could start with that, that'd be great.
That's perfect. So one of the first things that you guys that are under leases are probably worrying about, or have worried about, is whether you guys owe money to your landlord for time that you weren't able to use your premises or had reduced use of your premises. There are usually provisions in a contract that talk about unexpected situations like this. They're called force majeure clauses or casualty clauses. And a lot of people want a one-size-fits-all answer of, well, is this pandemic a force majeure? Does it qualify under a casualty clause? And unfortunately, the answer is it depends, which is, I think, the least helpful answer, but unfortunately, the honest one. One of the first things you should do is to read the contract, even if it's very boring. Read the lease very carefully to see what clauses talk about the issue, and see if it's written in such a way that describes things like there being a pandemic, but also there being a government order that reduces your ability to use the space. I looked at a lease recently that said that the obligations to pay rent under the lease were suspended if the government issued an order saying that the business that the lessee was operating had to be suspended. That's a perfect example of the situation we're in now. Not all leases have such specific clauses, so I'd urge you to look at these leases. But putting aside leases in particular and talking about contracts generally, you probably have vendors and customers that maybe don't want to deliver the goods they were supposed to deliver, want extra money for hazard pay, have customers that want to cancel their orders and not pay, that need extra time. A bunch of different issues could arise because of this pandemic. And the first, as I've been saying earlier, it is so much easier to have conversations with your other business partners than to have this in a litigation. Even if it means making a concession that you don't want to give, the cost of a concession is usually much lower than the cost of hiring someone like me to have a lawsuit. In addition to looking at all the written agreements to see, and let me back up one other time, a lot of people may also assume that contracts are kind of, in general, suspended because of the pandemic, and that is not the case. Courts are open right now and they're forcing people to abide by their contractual obligations, even though there's a pandemic going on. So if you have a contract that says that you are going to deliver 1,000 widgets by July 1, you can't say automatically, well, Of course, I'm not going to deliver the widgets. My factory got shut down. Courts will expect you to justify why you didn't deliver the products you said you were going to deliver. And you'll have arguments as to why that's the case, but it's not some sort of per se bright line rule that contracts are suspended right now. In addition to looking at all of your written contracts, you should consider all of the oral understandings you had. If you told a customer, I promise we'll deliver on this date, those are things that you should make a catalog of and make sure you're complying with, because even if you have forgotten about them, odds are the person to whom you made that promise has not forgotten, and they could go to court. In addition to like written agreements and oral agreements, and in addition to statutes, there's also a whole bunch of laws we call tort law and common law, things like fraud, negligence, fiduciary duties. There's a wide variety of obligations you have. And I think a lot of them go to the question that Rob asked at the beginning. Are you doing the sort of things that a responsible business owner should be doing? Generally speaking, if you are, you should be in good shape there, but it requires a lot of creativity on your part to think, am I doing those things? Because I promise you, there's a lawyer on the other side that represents your lessor or your customer or your vendor that's thinking really hard about how they can get money from you. And so you should think very hard about what they're thinking and then try to come up with some sort of compromise to avoid there being a dispute in court. One thing that you may also be considering is, listen, if there's a problem because of the pandemic, insurance will take care of it. That's often the case, but not always the case. And so maybe, Rob, this is an area where you can take over and talk about when insurance applies to obligations that are interrupted by the pandemic.
Right. So I'm going to give the Will Newman answer from a little bit earlier, which is unfortunately the very vague, it depends. So what we're seeing right now is, several trends, I'll say, in terms of from an insurance perspective. First of all, I'm going to go back to the workers' compensation piece that Will addressed a little bit earlier. Worker compensation rules under Osha are very specific, and they say that if there is a confirmed case of an employee, regardless of whether it's been confirmed or you're able to prove or not prove that it happened while at the time of employment, at the place of employment, that you need to make sure that you're filing it under Osha. The big thing that you'll hear from Will and I throughout will be, make sure you're documenting everything. Make sure you're keeping a record of all of the activities that either safety protocols you've undergone and continue to undergone, to any situations that may arise that you believe could lend itself to something from a legal perspective, or if there's a claim that you will or feel you might be putting through in the future related to COVID-19, you're going to want to have all of your information available and a time frame that's been attached to it. So workers' comp, takeaway there is make sure, regardless of whether it was proven that it was done that happened during the time of employment, make sure you're documenting that with OSHA. So that's the most important thing. So we're starting to see, as of really, even though this has been going on for the last 3 months or so here within the United States, or even 4 months, we started to see only as of last month where there's now claims that are starting to arise or be filed. And unfortunately, many of the claims are being rejected initially. And I'll talk a little bit about why and what to do on that. Where claims are coming in and they're not being fulfilled, and now legal situations are starting to arise in certain areas. So workers' compensation is one, and that's pretty, that's pretty straightforward in terms of making sure that it's documented and then proceeding from there. And there you want to make sure that you've got your carrier involved, your insurance carrier from the beginning. And you want to make sure that as much information as you can provide, you do so at the time of filing and then throughout. The bigger one that we're going to see, that we're seeing, and that there's, I'll say it's still a gray area. Will talks about, and we're on the slide right now of contracts. A policy, an insurance policy, is a contract. But as you've seen with many of the various types of insurance policies that you have or need to have for your business, there's an awful lot of pages that are attached to it. And with that, I'm going to talk specifically about, the two areas or the two types of policies that we're starting to see, or we have seen claims that are coming in on outside of the workers' comp. The first is your property, and the property really is, I'll say it's pretty straightforward in that, just like property insurance it needs to have a trigger. So when there's a fire, there's a flood, there's wind damage, there's a trigger as to physical damage that occurred at your property. In the case of COVID-19 and a shutdown that has impacted potentially your business, there really hasn't been a trigger. You can, and cases, and we'll go into it in a little while, cases have been made as to the trigger being civil authority closing me down. I'm not able to get in and out of the building that I'm, in this case, maybe leasing. So when you have these situations, you refer to your policy, and your policy, there really isn't a trigger. So the first question you have with property, if it's not going to be direct, and really the only way it can be direct is if something, you may have been closed down because that someone had maybe contracted COVID-19. You believe that it was spread through the HVAC system or the heating system. You had to shut that down to clean it, and because of the shutdown, your business interruption had occurred. That's one instance where, I'll say there's the gray area that we're starting to see. The other is, and that again is a direct situation. There was a direct trigger to the closing of the property of the business. The other one, which is, again, we go into the gray area, is indirect. And indirect takes the form of whether it be through civil authority closing it down, to not being able to go in and out of the building because maybe your landlord closed the building, to really any situation within the supply chain where some sort of occurrence, if you're supposed to be getting some sort of raw materials or finished goods from a supplier, and you haven't been able to get that, and that unfortunately has forced you to close. Again, it refers back to the business interruption is going to point to, all right, if it happened within the supply chain, was there physical damage that occurred at the supplier that you had? If there was a fire there that caused it, that's one thing, and that would be covered under a business interruption policy. But a lot of times it's because of, again, they're not being able to get you the goods or services they promised. They had to shut down because of 19, but there wasn't a direct trigger. So I think that those are some of those things to look at, and I'll say that 40% of the, and I don't want to go into Will's area, but more than 40% of the lawsuits that we have started to see have come only within the last 30 days. And it's because now they're starting to, the claims have started to come through initially. Unfortunately, many are getting rejected because there's no specific trigger, or a lot of times there's language in the policy that talks about pandemic or any kind of infections infecting your business, and that wouldn't be covered. But one of the things that we're talking to many of our clients as a broker, we advocate on your behalf is that make sure you have everything documented. Make sure you have the losses that you believe you have incurred because of this. Make sure that that's sustainable, and it's again provable in the ledger that you have, in the previous sales documents, anything and everything that's going to help in any claim that may have been initially rejected. And as I say, 9 out of 10 claims, regardless of the type of claim they are, have been getting rejected because of A, no one wants to set a precedent initially, and B, because of the fluidity of the situation, it's hard to really determine what was that true trigger, and did that trigger cause the loss that was out there, and where is it in the policy language. So don't, if you do believe you're going to take, the takeaway is, if you're going to take a stance of I'm going to file a claim, make sure you have all the information worked, make sure you're working with your carrier and your broker, and understand that you're probably going to initially get rejected, because of the fluidity of the situation. You can't open up a web page or turn on the news and hear, whether at a federal or a local or a state level, that there's one way or another, there's some sort of legislation being proposed about different situations for business interruption. So, that's why you're going to see more and more, and Will's going to be very, very busy in terms of from a legal perspective, is because it's a fluid area, and unfortunately it's a gray area that's not necessarily having been accounted for within the policy specifically. So let's go on to the next page.
And Rob, as we go to the next page, I guess there's three things that I thought of as you were speaking. One is the most recent thing that Rob said is that because a lot of claims are rejected because insurance companies don't want to set a precedent, it could be that you have a valid claim and the insurance company rejects it anyway because they're being particularly stingy or particularly narrow. And that doesn't mean that that's the end of your opportunity to get the insurance company to pay. That would be an area where it makes sense to talk to a lawyer and see if the insurance company denied the claim improperly. Second, I remember that a couple people earlier mentioned that they were lessees. And one thing that you could be held liable for in the United States, and particularly in New York, is if the landlord does something improper, you could still be held responsible under a theory of premises liability or an agency issue or some other legal theory that may be viable that would hold you accountable for a failure of your landlord. So if you observe that your landlord didn't keep the common areas of your workplace particularly secure, or had some other defect that you think isn't your fault but is the landlord's fault, you should not, I guess, rely on the fact that ultimately if someone gets injured or someone gets sick, that's the landlord's problem and not yours. It would still possibly be yours and you could be exposed and involved in a lawsuit. So I would press your landlord to make sure that the premises are just as safe as you would want them to be to protect your liability. And third, it occurs to me that a lot of folks here at the French American Chamber of Commerce, where Rob and I are members, maybe French business people or used to the legal system that's in place in France, where all of your obligations are kind of listed in the civil code. And in the United States, that's not the case. There is no one place that lists all of your obligations with respect to negligence, with respect to products liability, with respect to a number of factors that could be in play if people are at risk of getting sick. So I would encourage you not to limit yourself to looking to a list of factors, but instead to ask the wide-ranging questions we mentioned earlier. So in this slide,
well, before we go on to this slide, is you want to, you mentioned about, obviously we're both members of the FACC. With a lot of the members that are out there, we're fielding questions on a regular basis from a lot of membership. Feel free at any time. This is one of the great things about being a part of such a great organization like FACC, is that you have resources available just to talk to. You have a lot of folks going through the same thing, and I dislike, but I like it at the same time, the phrase "we're all in this together," because it's very much overused and used in situations that aren't always appropriate. But in this case, the fact is we're all going through something. It's impacting us in different ways. Having the ability to turn to folks that specialize in or are kind of living in the world that you may have questions in is invaluable, to be able to just kind of pick up the phone or shoot an email or get in touch with. And I know I speak for Will when I say, at any time, if you guys have questions that come outside of from here, I know every time I sit in on a webinar and then after the fact I'm like, oh, I should have asked this. Feel free to reach out to us. So I'll put in a plug about that. I'm a huge fan and supporter of FACC and the types of companies and the types of individuals that are part of the membership. So we're available to no question is too narrow or too simple, and none is too broad or too general.
That's absolutely true. And if you're one of the companies that supplies the cookies or like free pieces of ham or wine to the FACC events, I feel like I already owe you guys.
And the coffee too. The coffee too. Yeah.
Oh, I don't drink that. Okay, so the coffee people are on their own. I'm not helping you, but everyone else, please feel free.
And the bakeries.
The bakery people, they're really good. Okay, so let's say a dispute does arise where, you know, your landlord insists that you pay rent, but you feel that you don't need to, or a vendor says, listen, I came to your premises and I got sick, and you're like, that can't possibly be. What are the things that you should do in that situation? I would say the very first thing you should do is to try to negotiate a solution. Before you get, a lawsuit started, try to see if you can work something out. I will say though, that you should have a lawyer consulted or some subject matter expert that knows what a fair result would be, so that you don't make an unfair deal for you. But before going to a lawsuit, it is so much less expensive to make a concession or make a compromise and just work something out between business people than it is to have a lawsuit or to do formal legal work. So I urge you to do that, but talk to a lawyer first or some subject matter expert that's been involved in disputes like this before, that can give you a sense of what are the major arguments to make and what a good result would be. The second is mediation, that you could hire some third party to listen to both sides and try to get you guys to get to a compromise. Generally speaking, amongst lawyers love mediation. I'm kind of a dissenting view. I think that mediation can be expensive, and if the parties are very far apart, I find that it doesn't often bring them together. But most people disagree with me. So I would consider mediation, perhaps propose it, explore the idea, but it may not be worth the cost, at least in my view. A third thing that you should consider, and I don't want to say litigation is always bad because it's what I do for a living, but litigation is a tool that you can use if someone is being unreasonable, if someone doesn't live by their contractual obligations, or someone claims that they got sick when there's no possible way they got sick and the amount that they're demanding from you is exorbitant, then sometimes there is no alternative but to defend yourself in court. There's a bunch of reasons not to litigate. One, of course, is that it's very expensive, and not only is it very expensive, but it's unpredictable. You may have to produce a lot of documents, take a lot of time out of your busy work schedule to attend depositions and tell your lawyer a million things they need to know to defend you. And sometimes it's important to vindicate yourself, but I urge you to try to negotiate a solution first. And then, of course, the other thing to consider is to see if insurance will take care of whatever loss a third party is alleging. And Rob, you can talk about that.
I'll just add, from the perspective I talked about, making sure that you're documenting all your information. So I would say, regardless of the type of claim that you believe you're entitled to or you'd like to see, there's not a harm in putting through a claim, especially if there's one that you believe that's, from a validity standpoint. It now comes down to documenting the situation, whether it's the workers' compensation piece, and that's very hard to prove that it happened at the site. However, it's based on being an at-will or an employee, in the service of your company, and were they put in a position where they maybe were in more harm's way with the role that they serve, whether it's you're a first responder, whether you're someone in the retail area, or even the receptionist at the receptionist at the office building that you may work in. Does that put them in greater contact? So I'll say the workers' comp is one, and then from a documentation, and again, I stress that if there's something that arises, you need to make sure you get Osha involved and you file that like you would any other situation. And then the second is, regarding the property claim and the business interruption claim, frame the narrative. Make sure you're telling that story in its fullest, in terms of whether it's that you want to detail exactly the loss you had and why. You want to make sure if there was the direct damage that I talked about, because you had to, for instance, shut down the HVAC system, and that had to then take you out of the building, to, if you were impaired and you weren't able to get into that building, if there was some sort of civil authority that outlined exactly what the civil authority told you and for the time frames, and then again, correspond any of the losses from a business interruption perspective to those. So that's the big thing. And then get your carrier involved from a perspective with the workers' comp, as well as your broker. You know, many of you utilize a third-party broker. That's what we're here for. We advocate on your behalf. So keep that in mind in terms of, you know, they understand the system, they understand the types of documentation that'll be asked for, and they'll understand the best way to be able to frame that narrative as well. So let's go on to the next slide. Okay, just on this one, real quick takeaway is there's really three things to really think about whether you're reopening or that you're continuing your operations. One is your employees, and Will talked about this pretty well in the very beginning, is considering the risks associated with each type of employee. So you have employees / I'll put in there customers or any visitors to your location. You have that situation. You have a second, which is the physical workspace. Inspect everything. If you're reopening for the first time, did you check the roof? Did you check the HVAC? Did you check the fire system? Did you check anything and everything, electrical? All those things that would have been turned off or not being used, making sure that your workspace is going to be, when you reopen, ready to go. And then, I'll say in conjunction with both the employee and then the physical workspaces, managing that physical distance. So again, making somebody that's responsible for enforcement. We hope that everyone will practice themselves the best social distancing or physical distancing guidelines, but you as a business owner or a company executive are also responsible for that enforcement and or having someone that's going to help in the enforcement. And again, document everything. Let's go on as we're getting a little tight on time. Let's go to the last one. Okay. Will, you want to start with this one?
Sure, of course. And I know that we're tight on time, but I want to stress the idea of you making someone responsible. I think that I've spoken to several businesses that have great rules for their employees when they come back to keep the work environment safe. But if you don't put someone in charge of enforcing them, then it becomes difficult for a lawyer later on to say that you took those rules seriously. Okay, so I hope that this is the last pandemic we have to deal with, but as we've seen in other states, there could be second waves and there could be other pandemics in the future. So things that you guys should keep in mind in the future is, one, when you engage in contracts with vendors and lessors and any other party in the future, discuss now what you think should happen in the event there's another pandemic. It may seem far-fetched, but the times we live in are far-fetched. And so things that may seem that they weren't going to happen before are happening now. So things that may seem unlikely now may happen in the future. Also, as you make, work with customers now and with your landlords, consider the fact that what you're doing now will be considered a precedent in the future. That people will say, oh, you were able to deliver the goods during the last pandemic, so you should be able to deliver them now. So bear in mind that the way you act now will be used against you in the future. So, keep that in mind. Rob, you want to talk about the insurance aspect of this?
Sure. So several things that kind of come to mind. And I'll say it's for future shutdowns or concerns, but also it's just a general good business practice is that take the opportunity now to review your policies, because the policies are there to help. You're paying for a certain level of protection. What is insurance? All insurance basically is how much risk you're transferring in the form of maybe a higher premiums, and you're paying more for greater coverages, to how much risk you're transferring, how much you're retaining in the form of maybe lower premiums or higher deductibles. Either way, take the opportunity to review the policy so you know what is covered and what may not be covered. The second is many of you, one of the biggest things and why we were so busy when this first happened is we were working with a lot of our clients from an insurance perspective to knowing the coverages that they had, the opportunities. Were there ways that we can help and reduce the coverages where appropriate? And I'll give you an example. Obviously, you want to make sure that you still have the right coverages in place. But if you have 100 salespeople that are on the road constantly, and you have 100 vehicles that you have under a commercial auto policy, and those vehicles have been sidelined because no one's visiting customers or going anywhere, that's a perfect example of an easy, low-hanging fruit to reduce some coverages for the time frame that those cars are sitting idly by. So things like that, when you're working with your broker and you understand the policies that you have and the coverages you have, make sure that if there is a future shutdown, whether it's be for a second wave or another situation that arises as, again, this serious in nature, understand that there are maybe some areas that you can reduce some costs and without either reducing the coverages or just in cases kind of delaying payments or whatever it might be. And then I would also say is if you're closing up the business, ensure that you're doing the right pre-close inspections of the water, the electricity, the roof, anything and everything, because you don't know how long you're going to be not in that location. And then you want to make sure that when you open up, that you're doing or you're going back and checking those same things. Okay.
Okay, that sounds really cool. So if you have any further questions, we can go to the last slide here. Please feel free to reach out to us. If you have free samples of food as well, you can FedEx them to us. But thanks so much. If you have any questions, feel free to put them. If you have questions now, I've got nothing to do for the next couple minutes. So feel free to submit them in a chat. But otherwise, feel free to send us emails. I check it all the time.
Right, so just want to mention quickly, of course, that Will and Rob have graciously put their contact info here, so please do. But Will, Rob, I have two questions that I think are pretty urgent importance that I think we could spend the next couple minutes quickly just answering. First, is it recommended for business to completely shut down if an employee becomes ill after returning to work in the office? And the second one is, as you both mentioned, the US is not France, where the resource is in the civil code. So the question is, what is the final authority on what we should be doing in the US? So if you could, quickly answer those, I think that would be the most urgent ones we've seen.
Cool. Let me start with the first one about whether the right thing to do when someone gets sick is to shut the whole business down. And I hate to give the Will Newman answer, but the answer is really, it depends. And I'll tell you the things that it depends on. One is if your ultimate goal is to avoid future liability to other employees or to other people that could possibly be sick, then yes. I think that you have to weigh that though against whether or not you think shutting down the business will actually prevent an infection to another employee. And if you think that it will, then yeah, a good thing to do would be to shut down the business. However, I'll also say that there could be an argument that the employee makes that because you shut down the business, that is recognition on your part that it was the business that caused the employee to be sick. Now, there's a bunch of reasons why you could argue that that should not be the implication that a court should take by shutting down the business, but it's definitely an issue that will probably arise if there were a dispute. Also, you may say to yourself, if you think that there is very little risk that keeping the business open will infect another person, and the cost of keeping your business closed is great, you may decide that you're able to keep the business open and manage that risk. But very few things you do will provide no risk of litigation. Just having a business at all has some risk of there being a lawsuit because this is a litigious, culture. So I would say shutting down the business is a way to minimize that risk, but it may, not be necessary if you think that you're able to prevent additional infections. Rob, do you have anything more on that question?
So just two quick points. One is you made a great point about managing the risk. So every situation is going to be different. So again, I kind of said in the beginning when we talked about from a workers' compensation perspective, it's so hard to prove one way or another whether a worker actually contracted COVID-19 while they were in your employment or doing their job. So to Will's point is, are you setting a precedent now for each time? And if you now, again, if that's part of your safety protocol that you said that you were going to do, and you have that in writing that you were going to do, then you need to make sure that you're either adhering to that, you're updating it. But again, if you have safety protocols, and you should have safety protocols for all situations now, what does that say? And following that. And then the second thing is, again, just to kind of re-emphasize what Will said, is that, you have to, everything you do as a business owner or a business professional comes with a certain amount of risk, and how you decide that you're going to, for your business and for your employees, really becomes a personal matter, and how well you can mitigate it ultimately becomes a deciding factor, I think, in what you want to do moving forward. So you want to go to the second one, Will? You want to start with?
Sure. The short answer is there is no one place under American law where all of your legal obligations are written out. That sounds daunting and bad, but I think it's actually a good thing, and I'll tell you why. So our legal system has what's called stare decisis, which means that once a court decides a certain law applies to a certain set of facts one way, it will always apply the law or should always apply the law the same way to the same set of facts. And that means that unlike in France, where the laws will be written in kind of a general way, an employer should always maintain a safe work environment, or a contract must be respected unless there is an unforeseen event. American legal decisions will be very specific, and they'll say if an employer kept employees 9 feet apart, that is enough to avoid this type of negligence liability. So on the upside, the ability for us to tell you what is, will incur liability and what won't is it allows greater reliability than it would in Europe. But at the same time, it's harder for employees, or I beg your pardon, for employers or business owners to consult the law without a lawyer helping them out, because really only lawyers know all the different places to look for legal decisions and the type of legal decisions to look for. Most of these legal decisions aren't really available through Googling or searching online. They require a subscription to a legal service like LexisNexis or Westlaw, and then reading them, they're not very user-friendly. So it's the sort of thing that I would ask a lawyer their opinion on. But the good news is that right now no one's ever complained there aren't enough lawyers, and I promise there are swarms of them that you could ask for general advice. Is this okay? Is that okay? And many would be very happy, even not even charging money up front, just to give some sort of initial opinion, to tell you the sort of issues that they see in a set of facts that you propose to them.
Right. See, I have the benefit here of the final. So although there might not be a final legal authority within the United States necessarily, in my household, my wife is the final authority. So I have the benefit of relying on that. Outside of that, from from a business perspective or from a mental perspective, as we mentioned earlier, the situation is still fluid. So there may not be a precedent, or even if there was a precedent, with more information or another case that comes up, that could change the thought process. It could change any statutes that are out there that exist locally or statewide or federal wide. So, again, that's not a bad thing that there's no final authority, but understand that because the fluidity of the situation, because this is something that's unique and challenging, there's going to be a lot of discussion, a lot of debate, and there'll probably be, 245 million websites that are going to deal with COVID webinars, and a lot of them could be devoted to situations from a legal perspective, as Will said.
Well, Will, Rob, I want to just, wrap it up here, but I also just want to harp right back on if there are any more questions that you want to ask either of them, again, they've graciously put their contact info here. Please feel free to reach out, and they'd be happy to guide you the best they can. Will, Rob, I want to thank you so much for taking a chunk of your time today, this morning, and really going through all of these different aspects. As you mentioned from the get-go, it's complicated, it's tough, it always depends. So thank you so much for laying the groundwork for a lot of our members and for the people who are watching. To attendees, I just want to point out, and first of all, I want to thank you for coming, but also I'd like to point out that on Friday we have another webinar on the unconscious bias of voice. So looking forward to seeing you all there. Will, Rob, thank you once more, and really appreciate you again. Thank you so much, and have a great rest of your day.
Thank you,
Thanks, you
John.
guys. Bye.
Thanks, everybody.
Take care.